Welcome to the Docketing Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pooled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are about 2 webinars per month through May 2017. To see a complete list of webinar topics and to register for future webinars, go to the Webinars tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 7th in the series. Today's topic is Best Practices for Docketing Optional U.S. Prosecution Procedures. We have allowed time for questions at the end of the webinar. Questions may be submitted using the Q&A button on the control bar on your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. The presenters today are myself, Sherry Grun, and Meredith Wood. I am Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 19 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Sherry, please introduce yourself.
Sure, thanks, Ann. My name is Sherry Grun, and for the past 3 years, I have worked at Black Hills IP as a U.S. and international docketer. Prior to that, I worked for 10 years at Michael Best and Friedrich in Milwaukee, Wisconsin, 5 years as an assistant to IP attorneys, and 5 years in their docketing department. I have also worked in the corporate world and worked at Diversey Sealed Air for 5 years in the legal department as their only U.S. and foreign patent docketer, and I also helped with some paralegal work.
Thank you. Meredith, please introduce yourself.
Hi, my name is Meredith Wood. I've worked as an IP paralegal for almost 15 years. That includes patent prosecution, litigation, and docketing. I worked for a patent firm up in Columbus, Ohio for almost 11 years, as well as a firm here in Fort Worth for about 2 years. And I've been a docketer with Black Hills for almost a year now.
Great. Thank you both for participating today. Today we're going to cover the following topics: prioritized examination, also called Track 1, patent prosecution highway, PPH, and several special interview and appeal procedures, including the first action interview pilot program, after final consideration 2.0, pre-appeal conferences, and the more recent patent prosecution pilot referred to as P3. First, prioritized examination, referred to as Track 1. Track 1 is a procedure for expedited review of a patent application for an additional fee. It's actually quite a large fee. The USPTO's goal for prioritized examination is to provide a final disposition within 12 months of the prioritized status being granted. So it's an accelerated examination process. The Track 1 program grants special status to a patent application until one of the following occurs. The first one being the most important for us from a docketing standpoint, and that is Track 1 will remain in that status until the applicant files a petition for an extension of time. Other things that would kick application out of Track 1 status are the applicant files an amendment to the claims that increase the claim count beyond the allowed claim count for a Track 1 application, or the applicant files an RCE, or the applicant files a notice of appeal, or the applicant files a request to suspend action, or the office mails a notice of allowance or a final office action, or the application is abandoned, or for some other reason the examination is completed. If you want more information about Track 1 applications, I have a link with some good information from the USPTO's website in our slides. But again, as I said, the first item on that list is the one that docketers need to worry about most when dealing with Track 1 applications, and that is the filing of a petition for extension of time. So docketing tips with respect to Track 1 focus on that piece, that is avoiding the loss of the prioritized status of the application. And in order to do that, in order to avoid that, it's important to docket any response to a non-final office action in a way that would avoid an extension of time, which, as we just discussed, results in the loss of the Track 1 status. Now, Sherry, I know you have docketed a lot of Track 1 cases and office actions in Track 1 cases. When you receive an office action for a Track 1 matter, does the office action even indicate to you that it's a Track 1 matter?
No, the office action usually does not indicate that it is Track 1.
So that in and of itself is the first challenge, is recognizing when you're docketing that you have an office action that is a Track 1 matter. And if it doesn't look any different than a regular office action, that can be a challenge in and of itself. How do you get notified or alerted that the application you're working on is a Track 1 application?
It's been my experience that the docketing gets alerted to a Track 1 case sometimes when the case is originally filed, but most of the time when we receive the actual petition granting the Track 1 status.
Okay, so you receive earlier in the prosecution a document that tells you it's Track 1, but when you're docketing the office action itself, there's nothing in that office action that tells you. How do you docket, or what are your suggestions for docketing office actions in Track 1 cases?
There's a few different ways you could go about doing that. You could simply docket office actions the standard way your firm or company would docket an office action and add a remark noting that it's a Track 1 case. You could change the date type in a standard template from due date to final and exclude any extensions. Or you could set up a custom template for a Track 1 non-final office action that do not include extension dates. This option would allow for easier reporting, as your criteria would be specifically the Track 1 office action.
Okay, so the important thing to remember when docketing office actions in Track 1 cases is that Track 1 matters lose their Track 1 status if an extension of time is filed. And as I mentioned, that's a large fee. There was a large fee to file the Track 1 application, and that fee is basically wasted if the Track 1 status is lost because the attorney had to take an extension of time. Therefore, it's very important for the docketer to docket the office action in a manner that will prevent taking an extension of time. And there's different ways to do this. Sherry gave some great suggestions on some of those ways to do this. The second topic today is the Patent Prosecution Highway, or PPH. PPH speeds up the examination process for corresponding applications filed in other intellectual property offices across the world. Under the PPH, a participating patent office agrees that when at least one claim is allowed, the applicant may request a fast track or an accelerated examination of those corresponding allowed claims in the patent application in a patent office in another country. In order to have your application considered for PPH, you must meet all the criteria and submit a PPH request form. The PPH program does not require that the request form be filed at the time of filing the application. It's typically filed later in the process. If a PPH request is granted, the examiner will generally examine the application within 2 to 3 months from the grant of the PPH request. So from a docketing standpoint, and actually from a practical standpoint, The request to file a PPH, the request to get into the PPH program can be a tricky thing to docket because when an application becomes eligible for the PPH program is based on the status of the claims. So when you have claims that become allowed, that's when you can file your request for patent prosecution highway in another country. So given that, how do you decide when to docket or what to docket for a PPH request? Meredith, let's start with you on this one.
Sure. One way would be to have this on a checklist for docketing a notice of allowance. We use checklists religiously at Black Hills, and it's an incredibly helpful tool. So I think this being a checklist item is a great way to make sure the reminder gets on the docket.
That's a great tip, Meredith. Sherry, do you have any additional thoughts?
For some docket systems, such as CPI, it would be possible maybe to add another item within the allowance action. It could be something as simple as review regarding PPH opportunities. Also, if a foreign case is filed through the PPH, it might be good to add a comment identifying that it was filed through the PPH.
Just so you can identify that. Good point. Now, when you have a patent application that has multiple counterparts, a large family pending in many different countries, should you docket that review regarding PPH opportunities in all the family members in the case? Meredith or Sherry, what do you think on that?
No, it's really not necessary to docket PPH in all of the applications. It would only be necessary to docket in the U.S. application, and then just note in the remarks of the foreign application if it will be following the PPH.
Okay. So docketing PPH requests are tricky because of the timing, since there's no notices from the USPTO that tell the docketer that this matter is now eligible for PPH. Instead, there needs to be something that causes the docketer to add a docket entry to review or to file the PPH request. Again, this is another thing where there are multiple ways to do that in different docketing systems. And Meredith and Sherry, you had some great suggestions on how to do that. Next, we'll talk about special interview and appeal procedures and programs at the USPTO, specifically the First Action Interview Pilot Program, the After Final Consideration Program, the Pre-Appeal Conference Program, and the P3 program. If any of these are things that you're not familiar with or you'd like additional information, I've included links at the USPTO's website where you can go and learn more about these particular programs. Starting off with the First Action Interview Pilot. The First Action Interview Pilot allows an applicant to have an interview with the examiner upon request prior to the examiner issuing the first office action. So the examiner will do their normal prior art search, and they'll provide a condensed, what I would call pre-interview communication, citing relevant prior art and identifying their proposed rejections. When you receive that, you have 30 days to schedule an interview and submit proposed amendments to the examiner. If no agreement is reached about the claims in that interview, the applicant will receive a first action interview office action that includes an interview summary. And that office action really is the true first office action like we normally think about from the standpoint of docketing a first non-final office action. And I apologize, I hadn't advanced my slides there. So let's talk about docketing tips for the first action interview program. Meredith, I know you have docketed a number of these. What are the critical deadlines to consider as a docketer for first office action interview program cases?
Yes, first is the deadline to submit the actual request for the first action interview program. The PTO requires that the request be received at least 1 day prior to a first office action appearing in pair. For that, there are a couple of different ways to ensure that you timely file your request. Upon docketing of the application, you could docket maybe 60 to 90 days from the filing date to submit your request. Since the PTO doesn't typically examine applications that quickly, it's a pretty safe bet you're going to get your request filed on time. You can also set reminders to check PAIR for the first action expected date. This could be risky since the first action expected date is not always accurate. We all know the PTO could very well issue an office action before the date listed in PAIR. I can also tell you that customers that I docket for a lot of times include this request with the filing of the application. So in that case, you obviously wouldn't have to worry about any reminders. The second critical deadline is docketed after you receive your pre-interview communication. That document is received after your initial request is approved. The deadline for response to the pre-interview communication is 30 days, and that can be extended for up to a month.
Thanks, Meredith. Again, these can be tricky because, as Meredith said, you don't know when the first office action is going to be mailed. There are many ways to do this. What's important from a docketing standpoint is that you have a docketing procedure that puts a due date on the docket that is before the first office action is mailed. Otherwise, obviously, you miss the window of opportunity to talk to the examiner before they issue that first office action. Next is the After Final Consideration Program 2.0. The After Final Consideration pilot authorizes additional time for examiners to search and consider responses after a final office action has been issued. Under the After Final Consideration Program 2.0, examiners will also use that additional time that they're granted to schedule and have interviews with the applicant or the attorney to discuss the results of their search and and determine if that will place the application in consideration for allowance. So from a docketing standpoint, a request for an after final consideration can be filed anytime after the final office action is received in a non-provisional application. So anytime after you have a final office action, you can file a request for this. After final response deadlines still apply, including the available extensions for time. If the applicant declines the interview or is unable to schedule the interview with the examiner within 10 days of the date the examiner contacts the applicant, that's after you've made a request for this, then the examiner may proceed with an appropriate response to the submission that the applicant made after the final rejection according to the standard practice. So, Sherry, I know you see a lot of these after final consideration program applications. And Meredith, you also work with these quite a bit as well. Sherry, can you start us off and tell us where these show up in the communications from the USPTO and how you docket them?
Sure. I do see a lot of these, and they come attached to advisory actions and quite often with interview summaries. They will also come with notices of allowance.
Okay.
And when docketing, it's important to note that, first of all, if it's a proper request, and if it is, and accompanied by the advisory action, the response deadline of the final office action will need to be reopened. This is because the period for responding to the advisory action is calculated from the original final office action mail date.
Okay. So, Meredith, what do you do if the mailing date of the advisory action is more than 3 months after the mailing date of the final office action then?
Sure. I work in foundation IP systems a lot, and here's what you need to do. It sounds complicated, but it's really not once you get familiar with it. Again, when these come with an advisory action, if the mailing date of the advisory action is later than 3 months from the mailing date of the final office action, once you docket the advisory action, your response deadline is not going to launch correctly because it's not going to base off of the final office action date. Therefore, you're going to need to go in, remove that deadline that populated, and add a new activity, which is called the ADAF4 in Foundation IP. That will then allow you to enter the mailing date of the final office action, which will then correctly calculate your advisory action response deadline based on the final office action mail date.
That's a great tip for FIP users. So you said that activity was the ADAF4, right? And that will calculate the advisory action response deadline correctly when an advisory action is mailed after the 3-month date for responding to a final office action, correct?
Yes.
Great, that's great. That's a useful tip. Sherry, I know you have a lot of experience in CPI. What do you have to do in CPI to docket this, and in particularly to reopen items?
It would just be to simply reopen the final office action mail dates, as well as the appeal dates, if you had that on as well.
Okay.
It would also be good to note that if it does come along with a notice of allowance, you would simply just docket the issue fee payment date.
Oh, good point. So you mentioned the notice of allowance. How often does it come along with a notice of allowance? Does that happen very frequently?
Unfortunately, it doesn't happen as often, maybe 1 in 10.
Okay. Next, let's talk about pre-appeal conferences. The pre-appeal conference offers applicants an opportunity to request a review of matters on appeal prior to filing of the appeal brief. And the goal for the applicant is to identify the presence or absence of clearly improper rejections so they don't go up on appeal when they could have been quickly resolved prior to the appeal process, or to identify the omission or presence of essential elements required to establish a prima facie rejection. So with respect to docketing tips for pre-appeal conferences, the request for this conference must be filed with the filing of the notice of appeal and before the filing of the appeal brief. No extensions of time are available for filing the request for review after filing the notice of appeal. The time period for filing an appeal brief then will be reset to 1 month from the mailing date of the decision on the request for the pre-appeal conference, or the balance of the 2-month time period running from the receipt of the notice of appeal, whichever is later. Further, the time period for filing the appeal brief is extendable as well, just to make a note of that. So Meredith, can you talk about pre-appeal brief conference programs? And for example, do you specifically docket a pre-appeal conference request due date in all matters with a final office action, since this is something that can be calculated or done after final office action?
Not initially. You're going to have the 6-month pre-appeal brief request date on the docket along with your notice of appeal. And then when you file your pre-appeal brief request with your notice of appeal and you complete those dates out on your docket, a deadline to file the appeal brief will launch. After that, you're going to get your decision on the pre-appeal brief request. When you docket that, another appeal brief date is going to launch, so you're going to have 2 appeal brief deadlines with 2 different dates. As it specifies in the second bullet point in the slide here, you're going to use the later of those 2 dates. These instructions are also specified in the actual decision. However, it's not usually listed at the top of the document. It's usually in the middle or the lower region of the document, so it's easier to miss. Now, with these 2 different deadline dates, you will need to delete the earlier date.
Okay, so first of all, thank you for pointing out where to look for the deadline to file the appeal brief in the document. That's a very good tip. But I'm kind of hung up on the fact that you just said to delete something. We've had a couple previous webinars where we've talked about crossing off and completing deadlines, and we've emphasized that deleting things, meaning completely removing them from the docketing system, is a bad thing to do. So you just said to delete something. Can you comment on that?
Sure. Yeah, typically deleting dates on a docket is not something we ever want to do. But in this case, when you have two different deadlines for the same thing, if your customer goes into that docket and sees these two dates, they're likely to be confused, and we never want that. So we want one clear date, and we, of course, want to make sure we have the correct date on there for our customer to file.
Okay, that makes sense. That's for clarity then. The date's not completely being removed. You're still leaving one on.
Right.
Last, we have the post-prosecution pilot, P3. Many of you may never have heard of this. This is a pilot program that was launched in July of this year and only runs for 6 months initially, although many of these types of pilot programs often get extended, so that's why we're talking about it here. It started in July 2016. It runs for 6 months or until the USPTO accepts 1,600 proper requests. This program is similar to the pre-appeal conference program in that both programs, and actually not just the pre-appeal conference, actually in the after final consideration. It's similar to the after final consideration program in that both programs offer ways for the attorney to communicate with the examiner after a final rejection is mailed in order to try to resolve the case without having to go into an RCE. So docketing tips for this. First, there's a request form that must be filed within 2 months of the mailing date of the final rejection and prior to filing a notice of appeal. If the applicant is unable to schedule a conference within 10 calendar days of the date the office contacts the applicant, the request will be deemed improper. And the statutory deadlines for the final office action still apply and are not waived as a result of the P3 pilot. So again, the request for the P3 pilot, this must be filed within 2 months of the mailing date of the final rejection. Unlike some of the other deadlines that we've discussed today that can be tricky to docket because you don't know when an event will happen, this one's pretty straightforward. It's 2 months from the filing or the mailing date of the final rejection. However, just because it's an easy date to docket does not necessarily mean that it should be docketed. So Meredith, I'll start with you. Would you docket the deadline to file a request for the P3 program in every case just as a default when you're docketing a final office action has been received?
I think this is going to depend on the customer-specific instructions for docketing. Since this is such a new program and quite limited right now, my guess is this is not going to be something that a lot of customers are going to take advantage of. But again, it all depends on the customer.
Okay. Sherry, what do you think? Anything additional?
No, I would agree with Meredith. Docketing in all cases is probably not necessary, and consulting the customer to find out what they would like on their docket would be best.
Okay. Well, thank you, Sherry and Meredith. At this time, I want to remind our audience that questions can be submitted using the Q&A button on the control bar on your screen. I'll give people a minute to submit questions if they want to. Today we've discussed the best practices for docketing optional U.S. prosecution procedures. More specifically, we've presented docketing tips for prioritized examination or track 1 and the patent prosecution highway PPH and some special interview and appeal procedures. We will post the slides and an audio recording of today's program on our website, which is www.blackhillsip.com. When you go to that website, there's a webinars tab, and those will be available there. A couple questions in the queue actually related both to what I just said. So I have a question from Sonia. Will this webinar be available online to watch later? And the answer is yes. Allow us a few days to get the materials posted, but I'd say within a week they will be posted on our website with both the slides as well as the audio. And then same question from another viewer, will the slides be available anywhere after the presentation? So yes, again, both this presentation and previous presentations are all available through our website. And this is the 7th program in the series, so there's several other earlier programs that you may want to go and listen to if you haven't listened to the earlier ones as well. At this point, I don't have any other questions in the queue, so I just want to remind the audience of our next program. The next webinar in the Docketing Excellence webinar series is on January 11th at 1 p.m. Central Time. The topic is best practices and options for double docketing to reduce missed dates. Double docketing remains one of the best tools for risk mitigation in a docketing operation. Our next program will discuss the most common options for double docketing and how it can avert catastrophic mistakes. To register for this webinar, go to the Black Hills IP website. And thank you everyone for participating today. We hope you will join us for this upcoming webinar and other webinars in the Docketing Excellence webinar series. Thank you.